Good morning. Happy Tuesday. I had the opportunity to listen to the Lane Myers hearing from yesterday on my drive into work this morning, and eh, you know, uh, I am once again very impressed with Lane Myers, public defender. Excellent job. A really good job. Very good job in arguing his motions. I kind of poo-pooed the motions as I read them. But his oral argument on the motion was just great. I very much appreciated it. He is a skilled orator. The prosecution was very serviceable. Her argument was very serviceable, workmanlike. She had the easier position on all the motions, by far the easier position. And she did a very workmanlike performance. Nothing spectacular, but nothing to complain about either. Just a very solid performance. Defense attorney, excellent. Hers, solid. Lane Myers could not make a cogent argument if it bit him in the ass. He did nothing. He added nothing to that entire hearing except for a complete misunderstanding of the facts and the law. The dude doesn't understand the facts because he doesn't understand what things are. For example, he refuses to understand the difference between a public official and a public employee. And he seems to think that, every public employee has taken an oath of office. They're not in office because they're not public officers. They're not public officials. Like police officers are public officials. They take an oath of office. They swear to uphold the Constitution. Probably. I mean, I guess maybe different places will have different rules, but they're much more likely to swear to uphold the Constitution. But even that, I don't understand the relevance of that to any of his arguments. He just doesn't have cogent arguments. All of these things are in his mind and they just come out as a verbal diarrhea and they don't make any sense. Legally speaking, zero sense. On the motion to dismiss for the statute being vague and overbroad, I thought that after I read the motion, I thought it was a terrible idea. I thought it was very poorly informed. I thought a as applied motion would be better than on its face. And the difference between the two is the statute might be a perfectly valid statute, but as it applies to me, it's not valid because I am doing constitutionally protected activity. The as or on its face would be just on its face. This statute is invalid because it is going to just out of the gate, just on average, just by the very nature of how broad it is, it's going to capture all sorts of constitutional activity. But listening to his argument, I can see where he's kind of making sense, where he's saying look, if you have a legitimate purpose, this statute doesn't differentiate. I mean, if you're calling your congressman over and over and over and over and over again because you think that by being annoying, you're going to get the congressman to do what you want. By the way, here's a pro tip. Calling congressmen won't change their minds. Giving congressmen lots and lots of money will change their minds, duh. They don't go and get rich because people call them all day long. They go and get rich because people pay them lots of money to legislate the way they want, because politics. So I understand that. Okay, so how do you get that? Now, I think an argument could be made that one of the exceptions is lawful demonstrations, picketing, etc. And I think you could make the argument that the multiple calls are protests. You're calling them protest. You know that what you're doing is harassing them, but you're harassing them for a legitimate purpose out of a political protest. It's protected speech, yada yada. So as applied to you, that exception should apply, or it should be invalid. However, she's not a public official. She doesn't have there's no showing by Myers that she's crafting rules or regulations or anything like that are going to affect the general public. Like again, he fundamentally misunderstands the distinction between a public employee and a public official. Fundamentally misunderstands it. So, and I thought the prosecutor did a good job of pointing out that, like, under Lane Myers' interpretation, the janitor, you could just constantly spam and harass the janitor at your local school district because you dislike the way he bakes cookies or something like that, and he has no recourse against you, and the state can't prosecute you for harassment because, well, he gets public money as that's the source of his paycheck. And it just doesn't work that way. On the issue of the trying to eliminate some charges because of redundancy, that was a less awesome position. I understand the arguments that the defense counsel is making. I don't think it's super awesome. I mean, you got to make the arguments, right? You got to preserve it for appeal because you never know what the Court of Appeals is going to do. The Court of Appeals might just magically shit out something for you that didn't exist prior to you making the appeal, and all of a sudden you win now. So you've got to preserve the argument for appeal. He did that. It wasn't as promising. I wasn't as I didn't think that was as awesome as it first appeared. On further light, the final motion, the motion for a new bond hearing, I thought it was doomed from the start because, well, that statute is mandatory. It's a must. The arguments were very interesting. One of the things that this showed was the hole in the defense's argument at the no bond hearing, because he was arguing that the minute order wasn't filed until the 17th, I think, or something along those lines. The hearing was on the 14th and the minute order wasn't filed until the 17th. And I was under the impression, because I don't practice law in Arizona, the procedural issues, they escape me because I don't know what to expect. But apparently the judge made the order in open court. Lane Myers signed a pretrial supervision agreement. So he was aware of the order. He knew of the order. The judge apparently made a written order and signed it that day. And the minute order was just just a notice that this actually happened. So, but there was a written order on the 14th, and that order was communicated to Lane Myers in open court. So that previous argument wasn't very good. The current argument, as I understand it, is basically that the defense is going to appeal the First Amendment issue on the harassment statute, which again it's got legs. You never know what the Court of Appeals is going to do. It's not a bad argument. I'm not going to say it's going to win. I can't, it's the Court of Appeals has a lot of discretion, but it's a good argument. Like, it's a solid argument. It got me thinking while he was making his oral argument that he may be onto something there. I kind of was under the impression that he was in his motion. It seemed like he was blurring, there has to be some sort of an intent to do it with, there has to be the mens rea of intentional. And, there's a mens rea of knowingly, and your intent would be to knowingly do the thing. You're doing a thing. You're intending to do the thing, and you know what you're doing. You're not intending the outcome necessarily, but you're doing a thing that's going to give you the outcome. Intentional would be like I'm intending to unalive you, right? I attack you with a knife with the intent to make you unalive. Knowingly would be like, I'm throwing knives at you. I'm not intending to unalive you, but I know that by throwing the knives at you, that you have a significant probability of becoming unalived, right? So you're still intentionally doing things. You're still intentionally doing stuff. There's intent there. But the mens rea, the specific mens rea of intentional is only in the first one, where you're trying specifically to achieve the outcome of unaliving them, as opposed to knowing that what you're intentionally doing is probably going to unalive them. It's hard to wrap your head around. In law school, we spent at least a week in Crim Pro on mens rea and trying to figure out the distinctions between them, and there's gray areas. There's a lot in law. There's all sorts of gray areas about where intentional stops and knowingly starts, or maybe they overlap a little bit. And then below knowingly, it's recklessly, where you don't necessarily know that the thing you're doing has a high probability of unaliving someone, for example, with the knife throwing, but you should know. It's a lower standard of proof. So intentionally is the highest mens rea requirement, and intentionally encompasses knowingly. Knowingly encompasses recklessly, and everything below it. The intentionally encompasses knowingly, recklessly, or criminally negligently. Knowingly encompasses recklessly and criminal negligence. Recklessly encompasses criminal negligence. So, but his oral argument made it a lot more. Well, I think he kind of switched from there's no carve out for doing a thing that is lawfully permitted, like contacting your congressman. There's no carve out for that in the statute. And the prosecution's argument was kind of weak on that, where, reasonable person, would a reasonable person be harassed by this? And is the actual target of the harassment, were they subjectively harassed? And I think her argument was weak because the congressman is a congressman. He's not your average reasonable person, and the kind of behavior and actions that should harass a congressman it's a much higher standard than what should harass the ordinary reasonable person. For example, a congressman should be contacted about political issues. And if you contact your congressman every day about a political issue, well, probably that's not harassment. But if you contact your neighbor Bob about political issues and you scream over the fence at your neighbor Bob for an hour every day about politics, that might be harassment. It might be. I'm not saying it is. And that's also another thing, I know a lot of Lane Meyer supporters think, bright line rule. This is legal, this isn't legal. There's a lot of gray areas. I mean, law is full of gray areas. That's why you get an attorney to argue it for you. Another thing is, perfectly legal actions in and of themselves might not be legal if you do them with the wrong intent or in the wrong circumstances. Like going pee is perfectly legal. Going pee in public, possibly a crime. It's perfectly legal to pee. Yeah, but not in public. And it's the extra things in the statutes that turn what otherwise would be a legal action into an illegal action. So the calling someone with, or knowing that you're going to be harassing them, is different than calling someone without any intent to, or knowledge that you're going to be harassing them. If I call up an ex-girlfriend just out of the blue, maybe I don't know that it would be harassing for me to call her because I thought we broke up on relatively good terms. So the intent would have to be there. And if my wife hears this, no, I'm not calling up any ex-girlfriends. So the judge was very patient with Myers again. Myers has no idea what he's doing. He's literally incompetent, it's legally speaking. He has no idea what the law means. All of his time spent reading the laws, he has zero understanding of them. Uh, he's he's all vigor, he's all energy, he's all action, but zero understanding. So, I wish him the best of luck. Oh yeah, the no bond hearing, that was there were some weak points to it. The best argument that the defense attorney made was, we're gonna appeal. We think that you have the ability to allow for bond during the appeal on the issue of the First Amendment, the vague and overbroad statute. There is possibly some merit there. I'm gonna guess no, but you never know. The judge might just go ahead and do it, because really, what's the state gonna do? What's the state really gonna do? They might appeal, but during the time when the judge grants it and the state files its appeal, the defense is going to file its appeal. So by the time both appeals are heard and decided, they'll have achieved the goal of having Myers out during his appeal, if the court does it. And I kind of do hope the court does it. I'll be honest with you. I mean, I don't like anybody being in jail. I think Myers is dumb and wrong. I think he probably does have access to legal resources in jail, as much as any other prisoner in jail does. I think he probably does have access to LexisNexis. The state, or the jail, doesn't have any requirement. The state doesn't have any requirement to give him his preferred method of legal research, or to take out all the stumbling blocks. I mean, just the fact that he has access to LexisNexis itself should be sufficient. But he also has the attorney who's representing him on some counts, and is apparently elbow counsel on other counts. So he's got plenty of access to legal resources. I don't think that's going to be a good argument, unless the state is completely lying and he doesn't have the tablet with LexisNexis on it. There might be an issue with him having access to something to play videos on, if they're giving him videos on a thumb drive or something like that. But that's a separate issue. Well, it's not really a separate issue, but that's something that I don't know about. That'd be a factual issue. If he doesn't have access to that, then the court probably should order the jail to provide him access to a place to play the videos. But I think he's barking up the wrong tree on a lot of them, because most of those, he knows or should know what parts of those, the few videos of his that I've seen, or should know the thumbnails themselves. Like, come on, brother. But he's not being charged on the entire videos normally. He's being charged on the sections of the video where he's directing people, apparently, to harass her and putting out her information and things like that, for the purpose of allowing people to call her and harass her, because he thinks she's a public official. And he's wrong about that. So he's a public employee at best. Anyway, that's all I got for today. Thanks for watching. Have a great day.